Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Here's a case every law student needs to know for exam season. Have you ever seen a price tag that was clearly a mistake and wondered if the store had to honor it? Or maybe you're a business owner worried about a display error. Today, we're breaking down the landmark case of Fisher v. Bell to show you why a price tag isn't what it seems. Alright, let's start with the real-world problem. Most people think that if a store puts a price on a shelf, they're legally bound to sell it to you at that price. This is actually a major misconception that can lead to heated arguments at the checkout counter. Many shoppers believe that a price tag is a binding legal offer. In reality, if a store accidentally labels a $1,000 TV for $10, they usually aren't forced to lose that money. Understanding this distinction helps you manage expectations when you spot a too-good-to-be-true deal. It also protects business owners from devastating clerical errors. The case of Fisher v. Bell started in 1961 when a shopkeeper displayed a flick knife in his window with a price tag. At the time, it was lesser known to offer for sale such weapons. The shopkeeper was charged, but the court had to decide if simply putting something in a window counted as an offers in the eyes of the law. This distinction saved the shopkeeper from a criminal conviction. The court ruled that the display wasn't an offer, but an invitation to may help with. This means the shopkeeper was merely inviting customers to make an offer to him. This framework is the backbone of modern retail. It ensures that the final power to form a contract stays at the register, not on the shelf edge. Now that we know the history, let's look at how this invitation to may help with actually works in your daily life. It's the difference between starting a conversation and signing a contract. An invitation to may help with is basically a signal that you're open for business. Think of it like a help wanted sign. It doesn't mean the first person who walks in is hired. In a store, the display is just an announcement of what is available and at what suggested price. It allows the seller to remain in control of who they do business with. When you take an item to the counter, you're actually the one making the offer. You're saying, I offer to buy this item for the price listed. Until the cashier accepts your money and processes the transaction, no contract exists. This is why a cashier can refuse to sell alcohol to someone without ID, even if the bottle is sitting on the counter. The contract is only formed when the seller accepts your offer. This usually happens when the payment is processed or the beeps of the scanner occurs. Understanding this point of no return is vital for resolving disputes. If the cashier realizes a mistake before taking your money, they can legally withdraw the item from sale. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. If you're running a business, Fisher v. Bell is your best friend. It provides a safety net for human error and inventory management. If a staff member accidentally puts a 90% discount on a product, you aren't legally forced to sell it at that price. However, you should correct the error immediately to avoid bait-and-switch accusations under consumer protection laws. Fisher v. Bell protects you from contract law claims, but you still have to be honest in your marketing. Always double-check your shelf labels to avoid customer friction. Because a display is just an invitation to may help with, you aren't liable if you run out of stock. If a customer sees a display model and demands to buy it, you can legally say no if you have no more inventory. This prevents businesses from being sued for breach of contract every time a popular item sells out. It gives you the flexibility to manage your stock levels without legal threats. The Fisher v. Bell principle applies to websites too. Most online terms of service state that your order is an offer and the contract isn't formed until the company ships the item. This is why you might get an email saying your order was cancelled due to a pricing glitch. Without this legal protection, one small website error could bankrupt a small business overnight. While the law favors the seller's right to choose, consumers aren't left entirely in the dark. There are specific rules that keep the playing field fair. Even though a price tag isn't a contract, intentionally mislabeling items to lure customers in is lesser known under consumer protection statutes. If a store consistently makes mistakes that favor them, they can be fined by regulatory bodies. Don't confuse contract law with fair trading laws. One governs the deal, the other governs the behavior. Report persistent issues to local consumer agencies. Since the price tag is just an invitation, you're technically free to offer a lower price at the counter. In many retail environments, this isn't common practice, but for high-ticket items like furniture or electronics, it's perfectly legal. The store can then choose to accept, reject, or counter-offer. Remember, the sticker price is just the starting point of the conversation. Before getting into a dispute over a price, check the store's posted pricing policy. Many large retailers have a policy to honor a lower price if it's their mistake, even though they aren't legally required to, by Fisher v. Bell. This is a customer service gesture, not a legal obligation. Knowing the difference helps you stay calm and get a better result. Most retail disputes are small, but sometimes the stakes are high enough that you need to know when to call in the experts. If you're dealing with a business-to-business transaction involving thousands of dollars, the invitation to may help with nuances become critical. A simple email could be interpreted as a binding offer if not worded correctly. If a supplier backs out of a large order claiming a pricing error, you need a professional to review the specific language used. Small wording changes can shift a document from an invitation to a binding offer. For business owners selling restricted goods, like the flick knife in the original case, you may want to ensure your displays comply with local criminal statutes. Fisher v. Bell saved the shopkeeper because of the specific wording of the law. Modern laws are often written more broadly to include displaying as an offense. Consult a local licensing professional to ensure your storefront doesn't accidentally break the law. Taking a store to court over a $50 pricing error is almost never worth the cost. Legal fees and time spent will far outweigh the savings. Most consumer issues are better handled through small claims, court or mediation services. Always weigh the cost to fight against the actual loss before pursuing a legal claim based on contract formation. That's the practical version of what matters most in Fisher v. Bell. The big idea is to understand that a price tag is just the start of a negotiation, not a finished contract. Whether you're a shopper or a seller, knowing where the offers actually happens gives you the upper hand in avoiding disputes. Use this framework to stay calm at the register and protect your business from errors. If this helped you understand your rights better, like and subscribe for more practical guides. We help you compare the facts and choose the right path with more confidence. Check out Bar Exam HQ for more deep dives into the rules that run our world. Share this with a study group or anyone preparing for the bar exam. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.